matter of the King on the application of Tomlinson and the Secretary of State for the Home Department.
Yes, Mr. Baldwin.
Good morning, my lord, my ladies. I appear on behalf of the appellant. My learned friend, Mr. Michael Biggs, appears on behalf of the respondent. Just for some housekeeping matters in terms of documentation, the court should have a hearing bundle of 204 pages, an authorities bundle of 28 authorities comprising 455 pages, a supplementary hearing bundle of 43 pages, a supplementary authorities of making up 4 authorities, and now I think you should have a respondent's supplementary authorities made up again of 4 authorities.
Yes, except for the fact that we're one copy short of that last one.
They've found it.
Ah, they've found it. Right, good. Yes, we have all those.
I think there's a minor preliminary matter. There are 2 supplementary skeleton arguments, one from the appellant dated the 22nd of February and one from the respondent the 19th of February.
And a reply one from you.
Yes.
Yes, that's fine. We've got them all.
In terms of signposting, just to where I'm heading with my submissions, one, to set out the background of the circumstances, referring you to the documents. I have 4 grounds of appeal. I note the authority sent by the court to the parties, which is the Queen on the application of Yasser al-Suri. In light of that judgment, I think in the appellant's part, is strikingly similar to our grounds 2 and 4. I don't intend to make further submissions on that, unless the court needs me to. I'll more focus my submissions on grounds 1 and 3.
Can't remember which ground is which.
Ground 1 is there was no need for the appellant to make a further application. Ground 2 was the application of TB Jamaica and the effect of the FTT findings. Ground 4 is in regards to the alternative remedy and whether or not they should pursue the right of appeal.
Yes, I think we do want to hear from you on ground 2. It's not entirely distinct from ground 1 anyway, but
yes, it's quite similar.
Yeah.
They're interdependent, but my lord, I'm quite happy to do so. It's just I saw the case law; it was strikingly similar, but I have no problems going into that with you.
Good. All right. And before you don't have to tell us very much about the past history.
Yes.
Speaking for myself, I'd just like to be brought up to date. We've heard through your supplementary skeleton of the sad death of Mrs. Tomlinson.
Yes.
Where is the appellant now, and where is the baby now?
The appellant is in France.
Yeah.
Still in France. In terms of his son, I believe the son is with him in France at this stage.
Yes, I see. Right. Okay. Right. Okay. That brings us up to date. So the floor is yours.
Before I take you to the documents, I know you mentioned that the background history. Obviously, we have an appellant who's a national of Jamaica, date of birth 12th of January 1982. He's entered the UK in December 2000. On the 9th of November 2011, he's convicted of possessing an automatic weapon and sentenced to 5 years imprisonment. Now, he is deported, but while he's in the UK, he meets his future wife, Alicia, and they started in a relationship. Now, in June 2018, Alicia, with her family, travels to Jamaica and she marries the appellant. Because of the circumstances, Alicia relocates to France in February 2019, and the appellant joined her in June 2019, having obtained a residence card. This is after Brexit, but before the withdrawal agreement. The appellant's wife has a number of health concerns. They are both physical as well as mental. We have the familial adenomatous, which is precancerous cells of the bowel, as well as fertility issues. In terms of the mental, she was the victim of a sexual trauma and has mental issues because of that. While in France, Alicia has medical treatment on the NHS, so she returns to England every so often. And because of the layperson's assessment of the immigration rules, the appellant attempted to join Alicia for treatment in the United Kingdom on the 4th of July 2020. And if I take you to that document, which will be in the hearing bundle, this will be page 163.
Is the order of Lady Justice Lane.
162.
You want me to look at the PDF or the?
Well, I'm working off a hard copy, Mr.
Yes.
Falk.
They're same pages on
Yes.
this one. It's 162.
I don't know why it's wrong. I don't know. Anyway, okay. So it's the 4th of July. He's refused entry clearance. It says holds no prior entry clearance.
Yes.
And this results in him making or instructing solicitors, and he makes a human rights claim, which should be on 153, dated the 24th of September 2020. The heading is entry clearance to Mr. Lloyd Thompson, entry clearance for Mr. Lloyd Anthony Tomlinson. It sets out the background. It also sets out his life in France. It lists his partner's medical health.
Yes. I don't want to stop you, Ms. Barber. This is all set out in the upper tribunal decision. I appreciate you're here because you say the upper tribunal decision was wrong, but I don't think there's any dispute as to the sequence of events, is there?
Well, I think the emphasis I want to make only on this document, if I may, if you just scroll down after the documents, is the fact that a human rights claim is made for entry clearance.
Yes.
I think there's nothing more I can add to it at this stage. If I take you to the refusal, just briefly, and this is on page.
I mean, your point on this document is it's headed entry clearance and
But-
it asks for entry clearance.
Yes, it's headed. Oh, if I take you back, then basically I will. I think,
Both in the heading and the conclusion.
and the conclusion, yes, one.
Yeah.
But it's also based on Article 8. The Rasgar questions are set out in detail, and also the submissions made on deportation.
Yes.
Now, if we take you to the refusal letter, which is dated the 7th of June 2021, and this is on page 137. The second paragraph exactly explains, it has been decided to refuse your client's human rights claim dated the 24th of September 2020, and to refuse to revoke your client's deportation order. Now, if I take you to paragraph 13, there's bullet points because it sets out what the human rights claim is. Now, the bullet points I want you to focus on is the last three. It indicates the aforementioned very compelling circumstances. He provides emotional support, but the last bullet point is you submit your client should be granted entry clearance into the UK. That's the basis of the human rights claim. And then finally, at paragraph 73,
Yes.
we have the purpose of the appeal, which is they refused his human rights claim and they refused his application to revoke. Now, 74 explains your client does not have a right of appeal against the decision to refuse to revoke the deportation order. He may appeal against the decision to refuse his human rights claim.
Yes.
Now, during the time of, this is a right of appeal was granted. Now, during the time of the refusal decision and the first year tribunal hearing, which was on the 14th of September 2022, Alicia was diagnosed with cancer. And that became part of the appeal. If I take you straight to the appeal determination, again, I'll just refer you to a few paragraphs which I think are material. Essentially, if you look at paragraph 55 and 54,
Would it help if you told us the page you're looking at?
yes, my lord, my lady. Looking at page 62,
Thank you.
paragraph 54 and 55.
Yes, and the critical one is paragraph 55.
Yes. And at the end of paragraph 54, it said the indication of the interference that the respondent's decision to refuse entry to the appellant is having.
Yes,
So
this-
it's found to be a breach of her Article 8 rights, not his.
Well, it's part and parcel of both. So when you look at Article 8, you look at the partner, children, and the appellant.
Yes. I'm just pointing out the fact that it's found to be a breach of her rights.
Yes, yes, my lady. Now, the appellant, through his solicitors, because of this determination, sought entry clearance or asked for papers granting him entry clearance in the United Kingdom. This wasn't granted.
was there any attempt by the Home Office to appeal this decision?
Yes, there was an attempt to go to the
Can
upper
you
tribunal.
can you show us that?
It's not in the bundle.
Right.
It's not. I think it was just found there's no material error of law, and the decision was upheld. I think if I was involved in every aspect of the case, or I could say it was because at that time the first tier tribunal did not take into account medical treatment in Jamaica, because at that time they were in France, and the determination went towards medical treatment in France or the United Kingdom, but it wasn't considered that he is a national of Jamaica and she can go to Jamaica for medical treatment. I don't think I can take it any further than that. No
Anyway,
error was found.
Home Office made an application for
For
permission
permission.
to appeal.
Yes.
That was turned down in a decision on the papers, and
No, it was permission was granted.
Oh,
There was a
permission granted.
hearing before Upper Tribunal Judge O'Callaghan. He found there was no material error of law.
sorry. And that was as far as they could take it.
Yes. And on the 20th of June 2023, they revoked the deportation order. Now, the respondent insisted that a fresh or further application was required for entry clearance, at least on the online application. I wouldn't take you to that documentation, but what I will do is ask you to look at the supplementary hearing bundle. In there are the submissions made, or the cover letter for that application in August 2023. This will be on page 11.
Page 11 is the entry clearance, yes?
Yes. Now, this cover letter is very detailed, but in essence, I will take you that all aspects of the immigration rules are addressed, but in particular, we have exceptional circumstances, which is on page 21. It sets out the rule, Gen 3.1 and Gen 3.2, but then highlights that there was a first tier tribunal decision allowing
So it relies on the FTT.
yes, my lady.
And it's subparagraph B, isn't it, of 3.1? So, interestingly, at that stage, you're instructing solicitors. We're not saying that the Home Office was bound by the previous decision, rather that they were relying on Diva Sealand.
Yes, I see that. But I think our case today is that they have to give effect to that decision.
Yeah, I know.
Yeah.
That wasn't the way it was put at the time.
Yes, my lady.
Starting point. Yes.
If I can read. If I can refer you back to the original hearing file, and you turn to page 43. This is the decision from that application dated the 21st of August 2023. Under suitability, you see under the second paragraph, records held in the United Kingdom indicate you have been convicted of a criminal offence on the 9th of November 2011, and I've been sentenced to an imprisonment of 5 years. I therefore refuse your application under ECP 1.1 of Appendix FM and Rules S-EC 1.4a. Now, coming back, if you look at under eligibility, the appellant met all the eligibility requirements. He met all the eligibility relationship requirements. He met the eligibility financial requirements. He met the English language requirements. When they looked at exceptional circumstances, if you look at the third paragraph under that heading, on the following page, the respondent notes the mental health issues, the repeated miscarriages, the thyroid cancer, and the familial adenomatous, but then stated receiving treatment for these conditions, but found no exceptional circumstances.
No mention of the previous.
No mention of the previous determination. The appellant was denied entry clearance.
And this is just under 3 weeks after the Duncan Lewis letter of the 2nd of
Yes,
August,
my lord.
but it doesn't refer to it.
Yes, my lord.
Yes.
The decision does give the appellant a right of appeal. The appellant pursued judicial review proceedings instead and issued proceedings. It was initially refused on the papers by Upper Tribunal Judge Pickup. The basis was that there was an alternative remedy, essentially. The appellant renewed for an oral permission hearing, and it went before Upper Tribunal Judge Stephen Smith, which is on page 38. And the only focus I would say is that at paragraph 5, he does take into account that there is an alternative remedy. But still believe judicial review proceedings were appropriate.
Yes.
When we have a substantive hearing, this is starts at page 18. The submission being put forward is very similar to the one made here in terms of ground 1. There shouldn't be a distinction between the human rights claim and the application to revoke. They were one and the same. So if you refuse the application to revoke the deportation order, you're refusing the human rights claim for entry clearance. If I take you to paragraph 27 of the determination, page 25, the upper tribunal took a different view. They accept there was a distinction, but held that any human rights claim has to be assessed in light of the actual application made. And it was only the revocation of the deportation that was addressed, not entry clearance.
Which paragraph are you looking at?
Paragraph 27. The example is given of a student, because a student application doesn't derive a human rights claim. But if one was made in addition to it, it had to be assessed in accordance to the student application.
That's true, but that's apples and pears. The correct analysis, you would say, is that of the judge giving permission to go to the upper tribunal on page 39. You look at paragraph 5, look at paragraph 4. He's analysed it absolutely right.
Yes.
On your submission.
Yes, my lady.
They're two sides of the same coin.
Yes.
And it's underlined by the fact that that when you look at Judge Carbani's judgment, she actually does look both at Article 8 and at the deportation order.
Yes.
I mean, the upper tribunal judge in this case seems to have approached that on the basis that she didn't go that far, but
Yes.
in fact she did, so it makes it stronger.
Yeah, it's hard to do one without the other.
Yeah, well, he's
Yes.
saying you can't do one without the other as a result of the changes in the 2014 Act, but it doesn't matter because on the facts of this case, Judge Carbani addressed both.
Yes, my lady. Because the appellant was unsuccessful in the upper tribunal, application was made for permission to the Court of Appeal, which was granted on the 12th of November, 2024. Again, two intervening events. On the 12th of September, 2 months before, was the birth of the appellant and Alicia's son. And on the 24th of November, 12 days after the grant of permission, sadly, Alicia passed away. Now, 4 grounds are raised that I rely on. 1, there was no need for the appellant to make a further application for entry clearance. He made a human rights claim for entry clearance, which was also simultaneously an application to revoke the deportation order. A refusal of one was a refusal of the other. Ground 2,
So is the implication of that, if we were to accept it, that in order to properly implement Judge Carbani's decision, the Secretary of State ought to have granted him entry clearance then and there, without the need for a further
Yes, my lady.
application?
Ground 2 was essentially a further application was made. Every aspect of Appendix FM was satisfied, save that the respondent applied a different section to the suitability criteria to the same conviction that was part of the deportation order that was revoked. Further, the respondent assessed exceptional circumstances and found there to be none, despite noting all of the criteria set out before Judge Kabani. So our short point is, the respondent failed to give effect to the first-tier tribunal determination as per TB Jamaica.
Suppose you're right on the TB Jamaica
Yes.
point, and the exceptional circumstances should have been found.
Yes.
How do you deal with the suitability point? Because
But the rules indicate that if you can't meet any of the criteria and there's unjustifiably harsh consequences for the appellant, his partner or child, you should be granted entry clearance. It's why it's a high threshold of very compelling and justifiably harsh.
right. So even if he doesn't meet the suitability criteria, if refusal of entry clearance would be unjustifiably harsh, that's the trump card,
Yes,
you
my lady.
say. Right. So you're not pursuing any, just so that I got this clear in my mind, you're not pursuing an argument that it wasn't open to the entry clearance officer to find that he didn't meet the suitability criteria because the deportation order had been revoked.
Yes, I would say I am, only because they can use it if there's a change in circumstance. If there's more information out coming about the conviction or there's a further conviction, they can use this, but not on the same. Our position is that if it's the same conviction that was just revoked.
But does that undermine your ground one?
Well,
Because ground two,
Yes.
requiring an application for entry clearance,
Yes.
would be the only mechanism to assess whether there had been a change of circumstances.
but if there hasn't been, as it is in this case, then reassessing the same offence, and that obviously takes me to ground three, which I'll come to
Before
next.
we get to ground
Yes.
three, just pursuing my lady's question. Suppose that Alicia had sadly passed away earlier than she did,
Yes,
and that had happened as soon as the Judge Carbani's decision came out.
yes,
If you're right on ground one,
yes.
there would be an obligation to grant him entry clearance, notwithstanding that the whole basis on which the exceptional circumstances have been found was now no longer in place. And that can't be right, can it?
Well,
I mean, we're dealing here with the principle of
Yes.
whether or not he should be made to apply again,
yes.
and that can't depend on whether the circumstances have or haven't changed, but you can test it by seeing what would happen if they have.
If I could put it in this context, he's already applied. In our case, he's already applied for entry clearance, which is the human rights claim. That's the application made in August 2022. So if that's been decided in his favour, then it should be
Yes.
implemented. For them to ask him to reapply.
So you can't, you say, well,
we're not
that
sure.
that application should be implemented, and you can't deny the application of that application simply because circumstances have changed since.
No, I'll put it in this way. If I've applied for entry clearance and it's been assessed on a human rights claim basis and I'm successful,
Yes.
I should be granted entry clearance. If, however, in the interim, there's a change in circumstances, clearly the Home Office, the respondent is entitled to have another look if there's evidence of a change in circumstance. But they can't ask you to reapply hoping they find a change in circumstance. It's two different scenarios. They can't hope for one. It's either there is or there isn't. It's a binary question. I've made an application, I'm successful, I should be granted entry clearance. If there's a change in circumstances that's brought to the attention of the respondent, by all means they could look at it again. But what they can't do is apply and hope we find something or hope there's a change. There's two different things. I mean, I am a pessimistic, this is a pessimistic jurisdiction, I accept that. Everything has to be corroborated and proven. But there's a limit to speculation as to what circumstances are.
Maybe your really important ground is ground 2.
Yes. I know it's interlinked. It's because they actually, despite the findings, insisted that an application be made. And
Yes, I mean, while I accept your original application was for a
yes,
entry clearance, what the decision that actually came back that was appealed to the FTT, or was the subject of the appeal to the FTT, was the refusal to revoke the deportation order, which was appealed on human rights grounds.
my lady, if I may, I find it hard to find the distinction, only because the reason I'm asking for the revocation is because I want to be with
No,
my wife.
I understand. I understand that, but this is really, we're just talking about the difference between your ground 1 and your ground
Okay.
2.
There's not a lot. I think
Mm.
we did eventually make the application. I think because of the circumstances, the health issues, again, the findings, it was clear that time is an issue. So the application was made without any objection or challenge. But the fact that we have, I think, raises the second ground, because this corroborates for us what we believe to be the circumstance, in that if the Secretary of State is not allowed to rely on the same conviction for a different section of the suitability criteria, the application would be allowed.
Why is the Secretary of State not allowed to rely on a different section?
We say it's draconian in all its forms.
That's not an answer with respect. What's the principle that you're relying on?
I'll have to give you the facts to do that, my lady, if I may. We look at deportation, it's under, okay, suitability criteria is S-EC of the Appendix FM. 1.3 is if you're currently the subject of a deportation order.
That's a separate point.
Yes.
Yeah.
The Secretary of State is relying on 1.4, which has A, B, and C, which entails some form of imprisonment. You could only have a deportation order if you had some form of imprisonment. So in essence, if you've applied and revoked your deportation order, it involved you overcoming some form of sentence of imprisonment. If the Secretary of State is now allowed to rely on you having that same imprisonment for not conducive to the public good, you could see public law standards need to intervene.
It's
in our submission.
It's a different point, because the conviction doesn't go away and it's a separate rule. So irrespective of whether you have or haven't had a deportation order, the decision maker is looking to see whether or not you are the right sort of person to let into the UK. And the fact you've had a 5-year sentence for a firearms offence might have something to say about that.
But my lady, you can't do this outwit the previous proceeding, because you've just literally had a hearing regarding the revocation of the
But
deportation.
that may be your ground
Yes.
2.
That's your
Yes.
ground 2. That's
Yes.
what I was saying.
That's why I think it all comes back to ground 2.
Yes.
That you say the respondent failed to give effect to
Yes.
Judge Carbani's determination.
Yes, my lord.
And it's not that split hairs about whether a further application was necessary,
Yes.
but anyway, a further application was made with a
Yes.
carefully argued letter from Duncan Lewis,
Yes.
and the answer's no, and you say that fails to give effect to Judge Carbani's decision, that she wasn't determining precisely the same question, but you say it was so nearly the same question
Yes.
that the Home Office should have regarded themselves as bound by that determination.
My lord, I must admit, this is subjective submissions based on because every circumstance is going to be different. There's more than one way to revoke a deportation order. So there are different scenarios, but I'm looking at my appellant scenario and looking at that scenario and the findings made and the circumstances. and submissions is what we say our submissions have force.
Yes.
Ground 3 is very straightforward. If the Secretary of State position is correct and you have successfully revoked your deportation order, which is made under 1.3 of the suitability criteria, and then you have to make a further application for entry clearance where they could now apply 1.4a. As I said, any aspect of 1.4a, b, and c is involving some form of imprisonment, which would be why there's a deportation order in the first place. So if you have overcome a deportation order and then you have to reapply, can be refused under 1.4 for the same conviction and then have another right of appeal, means the Secretary of State is having a second bite of the cherry. And the interpretation or application in that way is draconian and subject to public law principle. I can't take it any higher than that. I rely on the case of our platoon, but I would get, there's not a lot of submission in it, it's just the approach. I think it's a common sense approach in what circumstances would happen or should happen. Ground 4 is the right of appeal and whether or not it was an alternative remedy. Our point is quite short. That should be dealt with at the permission stage. This was brought to the attention of the court. I took you to Upper Tribunal Judge Stephen Smith's.
Well, his answer is in subparagraph 5 on page
Yes.
39. We'll see what
Yes.
Mr. Biggs says about that. It seems to me on the most at the moment to be quite persuasive.
At the stage, we say the Upper Tribunal should have actually determined the matter because as the facts are not disputed, it's whether or not there were exceptional circumstances. And the answer was there in the determination. That finding could have been made if required. Now, in terms of ground 1, if I go very quickly through the authorities, if I can get this up, bear with me. If I take you to the authorities bundle, I will look at tab 6, page 57.
Not the original.
The original. We have page 59 is the revocation of the deportation order. These were the rules in force as of June 2021.
Yes.
We have paragraph 390. It indicates the grounds on which the order was made, any representations in support of revocation, the interests of community, the interests of the applicant, including any compassionate circumstances. (390A) explains it's only in exceptional circumstances the public interest in maintaining the deportation order will be outweighed by other factors.
He's into A398 because it's paragraph
But 398, if you're under
A, period of imprisonment of at least 4 years.
paragraph 391 indicates if you are in prison for less than 4 years, you can make an application after 10 years have elapsed.
But when
Yes, we're not in that. No. Again, at the bottom you see you can make an application before that if it's contrary to human rights, the Convention Protocol on relating to the status of refugee or other exceptional circumstances. 391A indicates the passage of time can be one of those circumstances.
We're not into that.
No.
It's 399B, isn't it?
Yes. Now 392 indicates the revocation of a deportation order does not entitle the person concerned to re-enter the United Kingdom. And we say there are many circumstances in which to revoke a deportation order.
Isn't that a complete answer to your ground 1?
I disagree, my lady, only because there's more than one way, which includes the passage of time.
Oh, wait a minute, just look
Yes.
at the language of
Yes.
paragraph 392. Why isn't that a complete answer to your ground 1?
Because,
Revocation of the order does not entitle re-entry. It renders him eligible to apply for admission.
my lady, my short answer to that is because there's more than one scenario to revoke a deportation order, and this was a human rights claim and taking into account the 2014 Act on Rights of Appeal and what a right of appeal entails, a refusal for entry clearance is a refusal of his human rights claim, not the revocation of the deportation order.
Well, it's
So what
both.
was refused was his entry clearance, and if it was granted, or by the first tier tribunal, then he is entitled to entry clearance. I can't take it any further. I do read 392, but I don't think it's all in. It has to be read in context of the statutes and circumstances.
Yes.
If I take you to the case of MY Pakistan, which is a
Do we
tab.
need anything else in the rules? What's the what's the difference in wording between what we've just looked at, deportation, where somebody has been sentenced to 4 years plus imprisonment, and the grounds for refusing entry clearance?
The suitability requirements, I can take you to that. This is on. This is tab 7.
Yes.
If you look at page 76, is section S-EC suitability entry
Yes.
entry clearance. We have 1.1. The applicant will be refused entry on grounds of suitability if any of the paragraphs in SC 1.2 to 1.9 apply. 1.3 is currently the subject of a deportation order. 1.4 has 3 criteria A, B, and C, which is at least 4 years, 12 months, and less than 4 years, and less than 12 months.
Doesn't the existence of SEC 1.4 as a separate basis envisage that there may be circumstances in which somebody has been convicted of an offence for which they've received a sentence of imprisonment of at least 4 years, but they're not the subject of a deportation order?
Absolutely, my lady. But our argument, it can't be one and the same, so it can't be and deportation, and then you've successfully revoked it, and then we've now decided to apply 1.4.
Well, that's where I'm having a bit of difficulty.
Yes.
Where's the human rights related exceptional circumstances or?
If I take you back up to 3.2, bear with me.
Thank you. Oh, it's in Gen.
Yes,
isn't it?
Gen. So we start at Gen 3.1, exceptional circumstances. It sets out financial requirements. If you look at Gen 3.2, it's where an application for entry clearance to leave is made under this appendix, or an application for leave to remain has otherwise been considered, does not otherwise meet the requirements of the appendix, or Part 9. Part 9 is general grounds of refusal, which is deception, false representations, as well as convictions. The decision maker must consider whether the circumstances in subparagraph 2 apply.
Yeah.
And there we look at the unjustifiably harsh consequences for the applicant.
Again, it's a reference to exceptional circumstances.
Yeah.
Yes.
Exceptional
Of course.
circumstances because of
Yes.
unjustifiably harsh consequences for the
Partner.
applicant or partner.
Yes.
And so on.
Yes.
Yes.
Does not otherwise meet the requirements. That's the particular paragraph.
Now, if go back to 2023,
Yes.
and you say that the only lawful response to the application for entry clearance, let's say it's in the Duncan Lewis letter for the moment, it seems to me not to matter. You say the only lawful response would have been to grant entry clearance.
Yes.
What terms, conditions could have been placed on the entry clearance?
Okay, in 2 ways. One, the appellant met all the rules, save for the suitability criteria. So that would have been a grant of leave, but under what we call the 5-year route, in that he has 5 years in order to grant settlement. If he didn't meet any aspect or part or none, as in case the suitability criteria, and you look at the exceptional circumstances only,
Yes.
he's granted on the 10-year route. So it's just a difference in time before he obtained settlement.
Sorry, I'm not sure I've quite followed this.
Okay.
What are you saying would be? Are you saying he would have got the 5 year?
No,
For how long would he have been allowed to come into the UK, I think is my Lord's question.
Yeah.
And would there be any conditions attached?
okay, he'll be allowed to come in for 2.5 years initially,
2.5.
whatever route for 2.5 years. There won't be any conditions, depending. They could be in terms of whether or not he accesses public funds, but there would be no conditions in terms of probation or.
No, it really we're concerned with what might happen were suppose you've got an exceptional circumstances
Yes.
and those exceptional circumstances no longer obtain because sadly Alicia passes away. Could the Home Office have said, well, you're allowed to come into the country for so many months after, provided that your wife is still alive?
Okay,
It sounds pretty heartless, but you see what's
okay.
up.
The usual grant is 2.5 years. The Secretary of State could grant however long they want.
Is that in the rules or is
Yes,
that
it's
just
that. It's in,
practice?
I don't think it's in. Yes, it's in the rules. I don't know if you put the whole rules in. Bear with me.
Is it 399B little a?
399B.
Yeah, so if you look at DECP, so this is on page 82,
Right.
and you look at D-ECP 1.1, except to a paragraph Gen 1.2 and Gen 3.2. You granted initial period not exceeding 33 months and subject to the condition of no recourse to public funds, then eligible to apply for settlement.
33.
Sorry, can I just read?
And then 1.2 shows if it's only Gen 3.2, which is the same 33 months, but settlement after 120 months.
Okay, so which do you say he would have fallen within?
Well, our first submission is that the Secretary of State should not have relied on SC 1.4a, therefore he'd have met the rules and he's entitled to 60 months. In the alternative, if the Secretary of State is allowed to rely on 1.4a, he would meet the exceptional circumstances and apply for settlement after 120 months.
But anyway, his original visa would have been for 33 months.
Yes. And then
Is this why there's a reference in the tribunal decision to
Yes.
a 10-year route?
yes, my lady.
Is that what
That's
this
what.
is?
That's what. Yes.
Thank you.
Would it, if somebody is Judge Carbani's decision is in effect, you wouldn't otherwise qualify to have the deportation order revoked. But I consider that it should be revoked because of the Article 8 needs of your partner who
Yes.
is very seriously ill with
Yes.
cancer. Would it have been lawful for the Home Office in response to the Duncan Lewis letter to have said that your client is granted entry clearance for an initial period of 33 months, or should Mrs. Tomlinson die within that period until, say, 3 months after her death?
I think in principle, the Secretary of State can give leave and conditions as the respondent sees fit. I don't think there's any, unless Mr. Biggs could correct me, but I don't see the Secretary of State being able to be limited. However, in practice, I think that would rarely be the case. I've seen in-country applications where they've limited only to a year. Normally, if you meet the rules, you would get the rules dictated in the rule, which is 33 months. It would be rare not to. However, when you apply to renew, the circumstances will be taken into account at that stage.
And
So-
the under DECP 1.2
Yes.
says an initial period not exceeding
Yes,
33.
not exceed. So it could be less.
So it
The
could
Secretary of
be
State could
less.
have been less. They could be less. I don't think it's against the Secretary of State granting less time. But I think in
And of
answer
course,
to my
since the entry clearance officer didn't get so far as exercising that discretion, we have no idea of how short or long entry clearance would have been granted.
yes, my lady. And again, when you mentioned the change in circumstance, if his partner passed, again, there's routes open to you because when you reapply, all the circumstances will be taken into account, which could be the bereaved partner route, or as they have a child, as the parent of a child, as the only parent there.
Soprano route.
And it'll still be articulate outside the rules, depending on the circumstances, whether it's unjustifiably harsh. But again, it's not you get leave and it's the end of the matter. Again, it was very precarious circumstances. Looking at the illness, the bereavement was something that was possible in any event. But that would be taken into account in any further application made by the appellant.
Right. So from what you say, that although commonly a grant of entry clearance under DECP 1.2 is for 33 months, it doesn't have to be, and sometimes Home Office say, well,
It could be less.
you can have a year and then you can apply again and so on.
Yes.
Thank you, that's very helpful. All right, do we need to look at any of the other rules?
Not from the appellant side.
No.
If-
Right.
If I take you to, I believe it's tab 8, which is MY Pakistan.
Yes.
This is, again, going towards ground one. I wouldn't spend a lot of time. The court has indicated its views, but I think what I would note, this was a case where the appellant applied for leave because of domestic violence. And he also made a human rights claim. Now, the Secretary of State made a decision on the domestic abuse application, but did not make, quite clearly in the decision, did not make a decision on the human rights claim, which they deferred. The appellant still went to the Court of Appeal, to the First Tier Tribunal on the basis that a refusal of the domestic violence application was also a refusal of the human rights claim. And if I just take you to paragraph 1, this is on page 84, is the introduction. I think the Lord Justice Underhill gave the decision. Yes, paragraph 1, the introduction, we have looking at the Immigration Act 2014. At paragraph 2, he indicates may appeal to the FT where the Secretary of State has decided to refuse a protection claim, has decided to refuse a human rights claim. Now, because we're focusing on human rights, at paragraph 3, he sets out section 113 of the Immigration of the 2002 Act, a claim made by a person at a place designated. If I move you on to paragraph 5, which start at the bottom of basis for leave to remain. Now, the immigration rules specify a number of bases or grounds on which a person may be granted leave to enter or entry clearance. Now, because it was focused on leave to remain, all of the paragraphs deal with leave to remain, but it's also equally applicable to entry clearance. I think if I take you at paragraph 19,
19.
Section 113, and you look at the case of Ashen, it says that in order for to fall within the terms of section 113, a claim does not require to be made in the form of a fee-paid application under the immigration rules. Now, the Secretary's position that a human rights claim ought to be made by a formal application in the interest of orderly decision-making. But she acknowledged that that was not the statutory requirement. At paragraph 23, this is, I would say, one of the marked differences. Secretary of State decision refusing the application is dated the 9th of September 2018. It gives you reasons for the decision, but a paragraph in the decision says any submissions you may have made relating to your human rights may not have not been considered as an application for settlement as a victim of domestic violence. It is not considered to be a human rights-based application. Therefore, if you wish to apply for leave to remain based upon your human rights or other compassionate factors, it is open to you to apply using an appropriate application form.
I'm not sure what the proposition is that you are citing as this case for, because
Oh, if I take you, if I can, is that basically the human rights claim, as there's no distinction between the human rights claim for entry clearance and the revocation of the deportation order.
but that's a fact-specific decision. I mean,
Yes.
this case is not going to help you because this case says it doesn't. Paragraph 41. It doesn't follow every application for leave to remain necessarily involves
Yes.
a claim that removal will be breach of convention rights. Absolutely classic law. You have to look at the facts and circumstances of the particular case. Your case, as I understand it, is that the two were inextricably intertwined in the claim that was dealt with by Judge Carbani. But I don't see what the principles in MY have to do with that.
If you look at paragraph 51, I think it just says if the second sentence of the ground one, whether it was necessary for the Secretary of State to engage with the appellant's human rights claim is for these purposes a red herring. If his case were that otherwise well-founded, the decision to refuse the application would necessarily be a decision to refuse the human rights claim, even if she had purported not to. It's considered to be as a separate claim. I think, my lady, my lords, you do have the point I've made on that. I don't need to press that forward. I think it's one and the same.
Right, where do we go next?
Ground two.
Yes.
This is the case of TB Jamaica. This is at tab 10.
Yes.
Bear with me. Everything just disappeared off my screen. Bear with me. Well, ground two is essentially, did the respondent give effect to the first-tier tribunal decision? The case of TB Jamaica, but also the case given to the parties by the court, are on the application of Yasser and Al-Suri, I think sets out what the contention is and in terms of how you approach this. Now, our assessment of the facts is that the Secretary of State refused the deportation order, which was made based on the conviction of the 9th of November 2011. Now, the human rights claim is made for entry clearance. In that decision, the Secretary of State did not refer to any other aspect of the suitability criteria, only focused on deportation. The upper tribunal, and I think the respondent's case is that, well, that's not the application made. When we're looking at the entry clearances, when we look at all the suitability criteria again, and that we're entitled to look at 1.4. Our position is very different. The first tier tribunal allowed the appeal based on exceptional circumstances in terms of the applicant's wife.
You say it doesn't really matter whether you met the suitability criteria, because once you're into that territory, you're outside the rules and you're into the provisions that say if it's unduly harsh consequences for the wife, it doesn't matter.
Now, in the case of Yasser al-Suri, there was a slight change in circumstance that was claimed by the respondent. That is not here in this case. There's no change in circumstance. They referred to it in the cover letter, setting out the findings of the first tier tribunal and why there are exceptional circumstances. The Secretary of State looks at it, notes all of the factors, but then decides without any reference to the first tier tribunal to say there are no exceptional circumstances. Now, whatever interpretation the respondent wants to persuade the court should happen, I think it's difficult for them to escape the findings of the FTT, the reference to it in the cover letter, and the failure of the decision maker to grapple with it. Ground 3 is our alternative ground. If we are wrong or incorrect on ground 1 and 2, we say the approach by the Secretary of State in terms of how they apply the suitability criteria is draconian and abusive and should be looked at in the context. I'm not going to take it any further. That's as far as I take it, relying on the case of Platoon. In terms of the suitability
Which case are you
oh, sorry, bear with me. It's
The one referred to in your grounds of appeal.
I can take you to that paragraph if I need to. It's it's on tab 9. Looking at paragraph 41. What happened in this case is a housing case. If you're homeless, the council is allowed to offer you other property without you having viewed it. If you didn't take the property, then you would be considered intentionally homeless. Although it wasn't made out in this case, I would say the principle is applicable.
Sorry, what
Paragraph
principle?
41. Sorry.
Oh, right.
Very different.
Because
Well, there's a reference there to oppressive decisions. That's
Yes.
what you're relying on.
yes, my lady, because as I said, not to recount it because I know the court is very much aware of the facts, but revoking a deportation order is not a straightforward process. It's a very high threshold to outweigh the public interest in continuing a deportation order. It's not simply an application to say, I have a relationship with my wife, I have a relationship with my child or mother. It has to be something more. If it's less than 4 years, you have to show it's unduly harsh. If it's more than 4 years, you have to show something very compelling. These are high thresholds. So if you are successful, and then you have to reapply, and then the Secretary of State is going to apply another section based on the same conviction, you have to go through the process all over again.
Well, either you're right or you're wrong about the exceptional circumstances. If you're right about the exceptional circumstances, it really doesn't matter whether the Secretary of State is entitled to apply the suitability criteria or not. If you're wrong, which is the hypothesis behind ground 3,
Yes.
then it seems to me, just looking at it, that you're not into Wednesbury territory at all, because you can't say that there is a harsh or oppressive or unfair, or however you care to put it, application of the rules in circumstances where there is no obligation to apply the rules in a particular way, because then you're into the field of discretion, and unless it's irrational, you can't simply say, well, it had really unfair consequences for me.
Well,
At the moment, I don't follow this argument as an alternative. I follow ground 2
Yes.
completely.
yes.
Now, speaking for myself, it seems to me if you win on ground 2, you don't need
Yes,
ground
no,
3.
I do not.
But if you lose on ground 2, ground 3 isn't going to save you.
No.
Ground 3 sort of, it's as though Judge Carbani's decision had never existed. And
Yes.
you're saying that it's oppressive on general principles. Well, I think you'd have a steeply uphill task.
But if I could just add one final point on that, only that if your circumstances is that, for instance, in this case, my relationship with my wife is the very compelling circumstance, then you have an appeal, the Secretary of State does not agree, and you have a right of appeal, and you've gone to court, and you've been successful. They've appealed to the upper tribunal, they have not been successful. Now you have to reapply on the same facts, on the same scenario, again, just because of the same conviction. It's almost like a doppelganger of...
But that is ground 2.
Yeah, that is ground 2, but okay, I'll take it no further. Ground 4 is the suitability of the right of appeal.
Ms. Balroop, at the moment, we don't want to hear from you on ground 4. My provisional view, for what it's worth, is that whether the right appeal route was used is water under the bridge now. If Mr. Biggs wants to try to persuade us that it's a point of importance, then we'll hear you in reply.
Yes. Is there anything further? Any other questions I could address?
Right. Thank you very much. Yes, Mr. Biggs.
Thank you very much, my lord and my ladies. What I propose to do, if it's convenient for the court, is to address 4 topics. Firstly, the statutory scheme and legal principles. And there are 3 aspects in particular that I want to cover under that chapter. The regime in respect of deportation, the scheme for statutory appeals under the 2002 Act, and the TB Jamaica principle, if I can call it that for short. Secondly, I want to turn briefly to analyse the First Tier Tribunal's decision of the 16th of September 2022. Thirdly, I will then turn to the grounds of appeal and deal with each in turn, although I appreciate that some grounds will require more attention than others. And finally, I will deal with the question of relief. It's not something my learned friend has mentioned in opening, but it is something I think I need to say a little bit about in the light of developments in this case.
Yeah.
So if that's convenient, my lord, my ladies,
Yes.
can I begin on down that road or path? Firstly then, the statutory scheme and deportation. The starting point is section 5, subsection 1 of the Immigration Act 1971. That is in the respondent's supplementary bundle on page 3. I'm afraid that's the bundle that only 2 of you have in the...
No, we've all got
Well, I
it
was
now,
going to say
thank you.
2 of you have in a more presentable fashion, and I'm afraid one of you has in a less presentable fashion. Apologies for that. But you should have the bundle one way or the other. So it's the first item in that bundle, page 3.
Yes.
And I've line marked the relevant part of subsection 5 of the 71 Immigration Act. It's the text in particular beginning, this is to say, this explains the nature of a deportation order.
Yes.
It invalidates any leave to enter or leave to remain. So you
Yes.
can't have leave to enter while a deportation order is in force.
And it constitutes a prohibition on entering the United Kingdom.
Yeah.
And just to be clear about the significance of this, what this means under the statutory scheme is that while a deportation order is in force, it is impossible for a entry clearance officer to grant entry clearance, or even, with my submission, to entertain such an application. Because before one can entertain the possibility of granting entry clearance, the deportation order must have been revoked. It must fall away because of the nature and effect of a deportation order. And that is reflected in paragraph 390, I think it's 392, isn't it, of the immigration rules, page 60 of the main authorities. So I'm sorry. Yes,
Yeah.
the page numbers of this should correspond to the PDF and the printed page numbers in the bottom right-hand corner.
Yeah.
So at the bottom of page 60 of the main authorities, behind, I think it's tab 6.
Forget about tabs. We haven't got them.
Oh, right. Very
Page
well, thank
numbers,
you.
I think.
Page 60, bottom of page 60.
Yes.
You have the text of 392 that my Lady Justice Andrews discussed with my learned friend in his opening, in the course of his opening submissions.
Of course, we've got the unusual situation where the person concerned has applied both to revoke the deportation order and for entry clearance in the same set of proceedings. And whilst that may be unorthodox, I think what is said is, well, there's, if you like, a moment in time between the decision on one and the decision on the other. In other words, necessarily the revocation of the deportation order also said you are now eligible for the same reason.
Yes, I think that is the case against me.
Yeah.
I mean, my submission is that under the statutory scheme,
Yes.
consideration of whether to revoke a deportation order is a necessary prerequisite and a separate stage to considering whether to grant entry clearance. And
I see how that works as a matter of looking at the rules and the law, but are you going so far as to submit to us that you can never make an application for entry clearance in tandem with an application to revoke the deportation order? In other words, you must always go through the hoop of asking for a revocation first and then, if you're successful, make yet another application.
No, my lady. And in fact, I'm not sure the course that was followed in this case is so unorthodox or unusual. What needs to happen is, from someone in the position of my learned friend's client, what needs to happen is that the Secretary of State or an entry clearance officer will need to consider whether to revoke the deportation order.
Yeah.
And very often, from a pragmatic point of view, the spur or trigger for that consideration would be an application for leave to remain or entry clearance.
Yes.
One in my submission, with respect to my learned friend, fundamental difficulty with the way he analyses the statutory scheme and presents his case is that it places too much emphasis on the nature of an application and the points raised in support of an application or representations, and the nature of the decision in response to the application.
Yes, I mean, obviously you say, well, whatever was said on the application, the actual decision
That's it, my lady.
was a refusal to revoke the deportation order. That was the decision that was subject of an appeal in the FTT on human rights grounds, and that's as far as it went.
Exactly. That is our submission. And so my learned friend's a difficulty with my learned friend is that it's not enough for him to say, well, my client asked for for a grant of entry clearance, and in the course of considering that request, the decision maker decided not to revoke the deportation order because because unless the decision maker had accepted that the deportation order was to be revoked, it was not possible for them to then go on and consider whether to grant entry clearance. And in any case, in this case, they stopped at the revocation of deportation stage. My ladies, my lord, I don't propose to take you to it in the interests of time and efficiency, but we do refer to the ZP India case, which may or may not be of some assistance on the question of how to approach applications to revoke a deportation order and the extent to which such applications are distinct from requests for a grant of entry clearance in terms of the Secretary of State's decision making. We've highlighted paragraph 23 in Lord Justice Underhill's judgment. That's at page 260. ZP India is at page 255. I'll try to avoid giving the tabs. So it begins at 255. Paragraph 23 is on 260. And the salience of ZP is that in my submission, it is entirely consistent with the point that I have made, that the revocation of a deportation order is a necessary prerequisite to even engaging with or entertaining, to use the word Lord Justice Underhill uses at paragraph 23 on page 260, with the possibility of granting entry clearance. And there is
I'm reading paragraph 23 of ZP India. What?
Let me turn to it, my lord.
It's the second sentence that I think is remarkable.
Yeah, I'm very grateful. Next to the dash.
Yes. The length of time before an application for leave to enter will be entertained.
Yeah.
That's the normal 10-year rule and so on.
Yeah. And that reflects paragraph 392, which I think his lordship may have set out earlier in the judgment. Certainly he was cognizant of it. I appeared in that case and I recall dealing with this issue. So when one, if one's an entry clearance officer, considers the edifice of rules that were considered in ZP, the rules in respect of revocation of a deportation order, one is looking at that question, whether to revoke a deportation order, not whether to grant entry clearance. It's worth, before I move on to my second topic under this heading, the scheme for appeals, just looking at Appendix FM in contradistinction to the rules that deal with revocation of a deportation order. We don't have, I don't think, the entirety of Appendix FM in the authorities. And so I'm not sure it will be particularly helpful to go through Appendix FM with my ladies and my lord in the authorities bundle. But what is clear, and I don't think there's any dispute about this, is that Appendix FM is dealing with applications of a particular type, applications to, in the context of entry clearance, to enter the UK in order to enjoy family life with a partner or child. It is not concerned with deportation. And there are specific and detailed rules set out in Appendix FM that govern that topic. And clearly they have to be viewed in contradistinction to the detailed and specific rules that deal with whether to revoke a deportation order.
Well, FM is supposed to reflect the case law, isn't it, and the jurisprudence in relation to Article 8, but leaves open the possibility of leave outside the rules so far as is possible. But you say that's stage 2. Stage 1 is, do we revoke the deportation order? Stage 2, would it be appropriate to allow entry clearance on human rights grounds?
That's right.
And that's when you get into Appendix FM.
Exactly, and to just sort of trail the point, Judge Carbani was only concerned with and explicitly concerned with, and as a matter of sort of logical implication concerned with, stage 1.
Yeah.
Does that mean that her decision is irrelevant?
I don't think I could be so bold as to say that her assessment of whether to maintain the deportation order was irrelevant to the consideration of whether to grant entry clearance after the deportation order was revoked. But I do submit firmly, with great respect, that her decision as to the compatibility with Article 8 of the Secretary of State's decision not to revoke the deportation order is a separate decision to the decision as to whether to grant entry clearance. And so what that means is that the issues before Judge Carbani concern that prior decision. And so her decision in respect of that prior decision just could not logically or on any proper, with great respect, understanding of the statutory scheme entail or require a grant of entry clearance. All Judge Carbani had decided, and indeed all Judge Carbani said in my submission on a proper understanding of her reasoning, was that to maintain the appellant's deportation, i.e. not to revoke the deportation order, would be contrary to Article 8. And she reached that conclusion by reference to the rules in respect of revocation of a deportation order, some of which we've looked at. She didn't look at all at whether the appellant should be allowed to enter the UK by way of a grant of entry clearance, and she didn't look at whether Appendix FM required that. None of the Appendix FM provisions were addressed, and indeed my learned friend does not seem to have argued that there should be a grant of entry clearance.
What?
Well,
The decision was under Article 8, not under the details of the rules.
Indeed it was, my lady and my lord, but it was an assessment of Article 8 in respect of the decision not to revoke the deportation order.
But with respect, isn't that a bit unreal? What she was really considering was whether it was contrary to Article 8 for Mrs. Tomlinson to be deprived of her family life with her husband.
Well,
and you look at the substance of what is decided, it's all about whether Article 8 effectively required them to be allowed to be together.
Well, I see the force of those points, my lady. I think strictly that is a slightly different point to the point I'm making.
I think you're still on ground 1, aren't you?
Exactly.
My lady is addressing ground 2, in which you're in somewhat greater difficulty.
Well, it may well be that ground 2 is probably what this case is all about.
This case is about ground 2, I think, but I think technically you're absolutely right on ground 1. Speaking for myself, I can see exactly why you say what you do about that. Nothing wrong in the Secretary of State requiring another application for entry clearance because the initial one has not been determined by anybody.
And could not have been determined.
And could not have been until the decision was made to revoke the deportation order.
Now, I'm sorry, mate. I was going to say, it may take some of the words out of my lady's mouth, and I apologise, but I accept that then there's a separate issue looking at the TB Jamaica principle, which I'll come to, as to whether the substance of Judge Carbani's reasoning is such that it was not open to the entry clearance officer to make the decision that was made, because, in effect, that would be to circumvent the binding decision of Judge Carbani, and I appreciate that raises some tricky issues, which I'll come to. But the Secretary of State is concerned about the implications of eliding those two stages, revocation of deportation orders and applications for entry clearance, because there is very good reason, and it's a well-established feature of the statutory scheme and the scheme under the immigration rules, to keep those regimes separate. And ground 1 does make the very specific point that it just wasn't open to the Secretary of State to say, well, you have to make an application for entry clearance. But strictly, and I hope what I'm about to say by reference to Part 5 of the Nationality, Immigration and Asylum Act will make this good, but strictly, the issues before Judge Carbani concerned the compatibility of the decision not to revoke the deportation order with Article 8. And that's why the judge doesn't look at the rules in respect of entry clearance or even make a decision that entry clearance had to be granted.
Sorry to interrupt your train of thought, Mr. Biggs, but just occurred to me this. Let's suppose your analysis is right. X applies for entry clearance but needs to get the deportation order revoked. So the Secretary of State looks at it and says, well, I'll have to decide whether to revoke the deportation order. I'm going to say no, and therefore I don't need to address the entry clearance application. I'm going to park it, right? It then goes off to the first tier tribunal. First tier tribunal says, you should have revoked the deportation order. Why does the person who has in fact made an application for entry clearance, which has never been addressed, have to make another one?
Well, that's because of the way the statutory scheme functions. I'll give my lady the quick answer before I develop the point and come to it. Under the statutory scheme, that would probably, or I say does, constitute a new matter, because the decision maker has not considered at all whether to grant entry clearance.
Yeah, okay.
And so, for better or worse, Parliament has made it very clear that the tribunal has no jurisdiction to look at that separate question.
No, but the point I'm
unless
making
the
is that the decision maker has jurisdiction, right? It's gone to the Home Office.
Yes.
Home Office has parked that question because it's decided I'm not going to revoke the deportation order, so I can't even engage with that. Right? Goes to the first tier tribunal. First tier tribunal says you've got to set aside the deportation order. There is still an application for entry clearance that has been made, which has never been addressed. And my question to you is, why do they have to make another one? Because it's been parked by the Home Office for perfectly good reasons, but the obstacle to dealing with it has now been removed.
I see that. Well, I think the correct analysis in that situation may well be, and I'm putting this point forward on my feet, but it may well be that effectively there has just never been consideration of that application for entry clearance, which is outstanding. And so in that situation, one would expect a well-represented appellant to say to the Secretary of State, well, I've got an outstanding application for entry clearance, please consider it. That's not this case.
No.
And indeed, in this case, there doesn't seem to have been a formal application for entry clearance. There was an informal, there was a letter. And so that point doesn't arise in my submission.
Sorry, you mean the original application was in the form of a letter rather than...
Yes. Yes. So the 24th of, I think it's the 24th of September 2000 letter.
Not in the prescribed form.
Exactly. So strictly, there was no pending application for entry clearance. There was, I accept, a letter that said, please let me come into the UK and refers to entry clearance. And that was then considered or treated as an application to revoke the deportation order, and a decision then said, no, we're not going to revoke the deportation order, but we've considered the human rights points you've raised in respect of your representations, and we accept that the refusal to revoke the deportation order constitutes the refusal of a human rights claim, and therefore you have a right of appeal. And I'll come on to how that all works right now, if I may. So, Part 5 of the Nationality, Immigration and Asylum Act, the 2002 legislation, that is, begins at page 10 of the main authorities. I think the starting point should be section 82 on page 11. This provision confers a right of appeal in certain circumstances. The relevant circumstance for our purposes is 82(1)(b). Secretary of State has decided to refuse a human rights claim made by a person P. That then requires, I'm afraid, a bit of jumping around to look at what a human rights claim is. That's dealt with in section 113, which is on page 44. This is the definition or interpretation section of the 2002 Act. It's been amended over time, and you see in the middle of, around the middle of page 44, or the text that's set out under section 113, two aspects to the definition. It's the second aspect next to the first square brackets with F3 written above it that's relevant.
Claim to refuse him entry into the UK would be unlawful.
Yes. Yeah. So that's the claim that has to be made. a person like this appellant has to say to an entry clearance officer, let me into the UK because doing otherwise would be contrary to Section 6 of the Human Rights Act, in particular because, in this case, breach of Article 8. So that's the definition of a claim. And if we go back to Section 82 on page 11, 82(1)(b), you'll see that's not the end of the story, if you like, for the purposes of 82(1)(b. There has to have been a decision to refuse that claim. And various cases have accepted that decisions can constitute a decision to refuse a human rights claim. In particular, in the Mujahid case, which is at page 430 and following. I don't propose, my ladies, my lord, to take you to it now, although we may need to go to it. In the Mujahid case, it was accepted that a decision to refuse an application for further leave to remain that either implicitly amounted to a human rights claim because of the nature of the application, or which was supported by human rights representations that were considered, that decision, the decision to refuse an application for leave to remain, constituted a decision to refuse a human rights claim because it entailed the Secretary of State's position that there was no legal bar to removal.
And that's similar to this case, isn't it? Because by accepting that there was a right of appeal in relation to the refusal to revoke the deportation order, that necessarily, by necessary implication, involved the refusal of entry, a claim to enter on human rights grounds.
Well, in
That's
fact, I think the letter was explicit, referred to refusing the human rights claim.
It did. It was the letter put forward a human rights claim. We accept that.
No, the
sorry.
response.
Yeah,
referred.
quite. Absolutely. Well, that's why we've not argued that there was no right of appeal.
Okay.
And why the entry clearance officer took the position that there was a right of appeal. There was a right of appeal, but it was a right of appeal, we say, from the decision to refuse to revoke the deportation order, because that decision constituted the decision to refuse the human rights claim. That's, in my respectful submission, the correct analysis of the statutory scheme in action, if you like, which is what the upper tribunal judge below accepted. And if you want to look at it, you may be assisted by paragraphs 18 to 20 of Mujahid, page 436, forgive me, 436, paragraphs 18 to 20. So that's the right of appeal. What then is the scope of the first tier tribunal's function once a right of appeal has arisen and an appeal is brought pursuant to it? That is dealt with by three provisions within Part 5 of the 2002 Act. They begin on page 12 and following of the main bundle of authorities, sections 84 to 86. 84, in my submission, is particularly informative, and it's 84 sub 2, relevant for our purposes. Page 12, my lord.
Yes.
An appeal under section 82(1)(b), so that's the territory we're in, must be brought on the ground that the decision is unlawful under section 6 of the Human Rights Act. The decision. And the upper tribunal judge below accepted the submission, we say rightly, that the decision that is referred to in section 84(2) is the particular decision to refuse a human rights claim, or that constitutes the refusal of a human rights claim.
Decision not to revoke the order.
That, yeah, you've got it, my lady. That's what we say happened here. And so, and this comes back to a question I think that my lady put to me. What was, or suggested to me, what was the first tier tribunal doing? What was Judge Karbani doing? Well, she was looking at whether the decision not to revoke the deportation order was unlawful under section 6 of the Human Rights Act, as she was required to do under section 84(2). And whatever her reasoning and the circumstances entails applying a proper understanding of the TB Jamaica principle, in respect of the issue that arises under ground 1, that in my submission should be enough to show that it was perfectly open to the Secretary of State to say, well, you had to make an application for entry clearance.
Yes. I don't think you need expend any more energy on ground 1. We're really much more interested in ground 2.
I'm very grateful. Right, but I am taking you through the statutory
Yes,
scheme,
no,
which is relevant to
right.
ground 2 too. But I'm grateful for the indication. And the relevance of the statutory scheme to ground 2 will, I hope, become a bit clearer when I get there. But the other provision that's relevant to the scope of the tribunal's jurisdiction is section 85. And that's the second of the 3 provisions I've referred to, which is on page 13. So this tells the first-tier tribunal what matters it can have regard to when considering the ground of appeal under section 84, that's available under section 84.
This is the fresh matters jurisdiction, isn't it?
Exactly, and my lady anticipates my point. The key aspect of section 85 to note for our purposes in my submission is that subsections 5 and 6 make it clear that the first-tier tribunal has a limited jurisdiction in respect to the matters that it can consider when considering whether the ground of appeal under section 84(2) is made out. In particular, it cannot consider a new matter, and that's defined by sub 6, unless the Secretary of State has given the tribunal consent to do that. And the reason for this provision is to preserve the primary decision-making function of the Secretary of State. And for better or worse, that is the decision Parliament has taken.
And there's some guidance on it,
Yeah.
which I was looking at only yesterday in another matter. And so the position is that if somebody had wanted to run an application for entry clearance, which was not before the upper tribunal, they could do so with the consent of the Secretary of State, but not otherwise.
But not otherwise. In this case, there was no attempt to do that. And so the tribunal didn't have jurisdiction. There is guidance on what a new matter amounts to. You've got the statutory words in sub 6. I won't spend time trying to unpick them. They're there for the court to consider. Mr. Ockleton, when he was vice president of the upper tribunal IAC, explained how the new matter provisions work in a case called Mahmood, which is at page 7 and following of the respondent's supplementary authorities. And I just highlight head note, paragraphs 2 and 3 of the head note, and paragraphs 29 to 32, beginning on page 17 and finishing on page 18. They've been line marked. But the upshot of...
So sorry, second bundle, third bundle.
Whichever label you want to
new
give it. It's the respondent supplementary
Third
authority.
authorities bundle.
I resist the urge to get into why there are so many
No,
authorities.
We're not apportioning blame.
Right.
So upper tribunal decision, Mahmood.
So it begins at 7, head note 2 and 3, and paragraphs 29 to 32, beginning on 17. So that explains authoritatively how the new matter provisions work. And the bottom line, if I can put it like that, is that if the appellant wanted to rely on Appendix FM and wanted to say the Secretary of State should not only have revoked the deportation order, but should have granted entry clearance, that would have been a new matter. And so it wasn't open to Judge Carbani to consider that in the absence of consent having been requested and granted by the Secretary
I've
of
had a
State.
shot at doing that actually, a fairly good shot under the policy, because it was already something that had been put for the Secretary of State, albeit informally. But the Secretary of State would have been perfectly entitled to say, well, no, you've got to pay the fee.
Quite. I suspect my lady has perhaps dealt with a case that looks at the policy not sure whether there's judgment or one that's awaited, but yeah, that's quite right. But this is a jurisdictional provision, and whether my learned friend would have been pushing at an open door if he tried to get this in or not, he didn't get
We
it
don't
in.
know, he didn't try.
And understandably, therefore, the First Tier Tribunal didn't look at entry clearance or Appendix FM. So that brings me to the third topic under my first chapter, TB Jamaica principle. And I think my Lord Justice B may be very familiar with TB Jamaica.
Well, I must say I'd forgotten about it until I read the papers for this case.
Where you were vindicated. So.
I note that it was an extemporary judgment. Anyway, it was a long time ago.
And I think, my Lord, the Court of Appeal said complimentary things, but can we turn to TB Jamaica?
Yes.
It's at page 1440. I'll just zoom straight into the salient passages, if I may. Paragraphs 28 to 34, beginning on page 150. The court will need to go through these passages at a slower pace. But the key propositions that I extract from these passages are essentially encapsulated in paragraph 32, page 151. So a decision of the First Tier Tribunal that is unappealed is binding on the Secretary of State. Because otherwise the statutory scheme for appeals would be undermined. There is an exception which is mentioned at paragraph 35, or exceptions that are mentioned at paragraph 35, covering change of circumstances and what later authorities have clarified as a Ladden-Marshall exception. But we're not in that territory. Except that the application for entry clearance inevitably required an assessment by reference to the up-to-date circumstances and the particular points that were put forward in support of the application for entry clearance.
Is this leading up to a submission that Duncan Lewis are right to treat it as a Diva Sealand situation rather than an issue estoppel?
Yes, I think that is the right analysis. But before I get there, can I crave the court's indulgence with one further reference to an authority? The Al-Siri case, which I have to say we're very grateful for the court's efforts in bringing it to our attention. It's at page 47 and following of the Secretary of State's supplementary bundle of authorities. So right at the end. And there are two key aspects of this decision that I will need to deal with. Firstly, the court's understanding of the TB Jamaica and its scope, TB Jamaica principle and its scope, and I'll deal with that now. And secondly, the court's reasoning in respect of alternative remedy, which, if I may, I'll come back to if I need to in respect of that ground of appeal. It may be that I don't need to spend much time or any time on it in the light of what's been said by the panel. But in respect of the scope of the TB Jamaica principle, it's paragraph 51 in particular in my submission that is illuminating. That's on page 60 and going over to 61.
Is this TB or Al-Siri?
This is Yasir Al-Siri, which I'll call Al-Siri if I may.
Yep.
Page 60 of the respondent supplementary bundle, paragraph 51. What, on my reading of Al-Siri, what the Court of Appeal is saying is that the TB Jamaica principle is not just about what the First Tier Tribunal decided in the sense of whether a particular decision was held to be unlawful. It does sweep in something like a Henderson and Henderson abuse of process. And that is what the court in the preceding paragraphs, the paragraphs preceding paragraph 51, is in my submission explaining by reference to a whole line of authority culminating in Virgin Atlantic Airways and Zodiac that looked at res judicata and finality more generally. So we accept. Indeed, and I think, if I may respectfully say so, it was probably Lord Carnworth in the DN case that sort of set this hair running, because up until that decision, public lawyers have been a bit wary about invoking issue estoppel, particularly in immigration law, but that sort of opened the door, and we now have Al-Siri explaining TB Jamaica in terms of those more conventional principles. And the court may recall that in TB Jamaica, Lord Justice Stanley Burnton expressed the preference to use language other than abuse of process in expressing his the reasons for his decision. He said that he was concerned with the principle of whether the FTT's decision was binding. He didn't want to use the language of abuse. But I accept that in the light of Al-Siri, the principles in respect of issue estoppel and finality do seem to be relevant here. Unless there are any questions about the legal scheme, can I turn to my second topic, the analysis of the First Tier Tribunal's decision? I think I can deal with this pretty briefly.
So just to
I've
be
trailed
clear,
most of the points.
you do not disagree with either the label or the application of principles of res judicata in the context that we're considering them here. That's what I understood you just to say.
Well, my understanding of Al-Siri is that the court interpreted the TB Jamaica principle as being informed by broader principles of finality. But strictly, the TB Jamaica principle is concerned with the effect under the statutory scheme of an unappealed decision of the First Tier Tribunal. In other words, the TB Jamaica principle is about the extent to which a decision of the First Tier Tribunal is binding under the statutory scheme. And it's those words, the extent to which are potentially particularly significant in respect of ground 2, and which the Al-Siri case sheds some light on. Because in particular, it was recognised in Al-Siri that it's not just, you don't take a narrow approach to the binding effect of the First Tier Tribunal's decision. You look at whether as a matter of, whether points that could and should have been raised before the First Tier Tribunal are being used to, in effect, circumvent the binding effect of the First Tier Tribunal's decision. Now we say, when I get to ground 2, and I'll develop this, we say that on a correct understanding of the statutory scheme, the First Tier Tribunal's decision did not, it wasn't necessary for the Secretary of State to put forward a case about entry clearance before the First Tier Tribunal. And I'll develop 4 at least reasons why I say that's the position.
That's not
when
the
I get
point
there.
you've got to meet. Nobody's running Henderson and Henderson. It's a much more straightforward point against you, which is that the decision of the First Tier Tribunal necessarily decided that it would be a violation of Mrs. Tomlinson's human rights not to allow her husband to come into the jurisdiction. That was binding on the Secretary of State. And when it came to the question of entry clearance, that couldn't be got round and had to be given effect. That's the case against you. It's nothing to do with Henderson and Henderson and not bringing forward another point.
Very well. Well, my answer to that is that that's not what the First Tier Tribunal judge was deciding, bearing in mind, and I've taken you through the statutory scheme to build up to the point. The First Tier Tribunal judge was looking at whether the decision to revoke the deportation order was contrary to Article 8. And the judge said that. It said that it was contrary to Article 8, but didn't say more.
In the course of that, they've necessarily decided the issue of whether it would have unjustifiably harsh consequences.
This is why the reference to Zodiac and so on is potentially illuminating,
Mm.
because this isn't Henderson abuse, you could have raised the point and you didn't. This is that the issue of Article 8 was decided by the FTT.
Yes,
That's the point that you need to address.
I'm grateful, and I acknowledge that. And my submission is that the first tier tribunal under the statutory scheme simply was not seized of the issue of whether that it would be contrary to Article 8 not to grant the appellant entry clearance. That was not, on a proper understanding of the statutory scheme, the issue that was before the judge. Now, I accept that the issue that was before the judge is, should the deportation order be revoked given the demands of Article 8 and Section 6 of the Human Rights Act? I accept that the reasoning the judge deployed in respect of considering that issue would be relevant to the question of whether the appellant should be allowed to enter the UK in respect of, or should be granted entry clearance to facilitate that. But they are different issues under the statutory scheme. And as I pointed out, the issue of whether the appellant should be allowed to enter the UK pursuant to a grant of entry clearance was one that the first tier tribunal was barred from considering because it would have amounted to a new matter.
Yes, we've got
So
that.
that
We,
I
we
appreciate
understand that. That's the formal difference.
Yes.
But the point you have to meet is whether the rationale for Judge Carbani's decision must apply to the entry clearance decision.
The answer to that, my lord, is that would be an extension of the TB Jamaica principle. I see that my lady's shaking her head. Because the issue that was before the first tier tribunal was not that issue.
The necessary step to deciding that issue, and that's where issue estoppel comes in, whether it's in public law or in private law. That's the point. If it is a necessary step in the chain of reasoning in deciding that it's going to be wrong to maintain the deportation order, which is the bar to entry, and it said it's going to have unduly harsh consequences on Mrs. Tomlinson to not let her husband come in and stay with her while she's ill, then you can't divorce the reasoning from the end result for the purposes of an estoppel. That's the problem you face, Mr. Biggs, it seems to me.
Yes, I acknowledge that, but that is strictly speaking different from the argument that's put against me, which is that there had to be a grant of entry clearance to comply with the first tier tribunal's decision. I've accepted that the first tier tribunal's reasoning in respect of Article 8 was a relevant consideration and had to be respected.
Do you accept that even on your analysis, which I think you said was a Sealand type analysis, that the entry clearance officer simply hasn't grappled with the fact that the first tier tribunal decision has said something different?
I have to acknowledge that the reasons make no mention of it, and on that basis, I think I would have to accept that. And that takes me straight to ground 4, which I'll come to. But I appreciate.
I don't want to take you out of your way on ground 2.
No, I'm very grateful. So, I think probably I don't need to say a huge amount more then on the analysis of the first tier tribunal's decision. Well, perhaps if I think it's probably worth just, if you'll indulge me, going back to the 7th of June 21 decision and then the first tier tribunal's decision. So the 7th of June decision is at page 137, and I'll just take you in the core bundle. And the court's considered this, so I won't spend much time on it, but I think it's important to focus in on paragraph 64 down to 73, which begin on page 150, because this makes clear what the decision maker was doing. Whatever they were asked to do, these paragraphs make it very clear what the decision maker was doing. And you get, so they are applying the rules in respect of whether to revoke a DO, if I can put it like that.
Yeah.
And then at 73, they say we're not going to do it. But it's acknowledged in the following paragraphs that there's a right of appeal because it's accepted that a human rights claim is made, and the effect of the decision not to revoke the deportation order is to refuse that human rights claim. And that's because, as I've explained, the deportation order amounted to a bar on entry. So by maintaining the deportation order, that necessarily meant that the appellant was not permitted to enter the UK. And thereby his human rights claim was refused. So the decision that was under appeal was constituted by the decision to refuse the deportation order. The first tier tribunal's decision of the 16th of September 2022 is at page 47.
Yes.
As I think the upper tribunal noted, in paragraph 3 on page 48, Judge Carbani categorised the decision under appeal as a decision to refuse to revoke the deportation order.
Yeah.
And we get to the judge's reasoning from paragraph 51, 60. And again, the court will have spent some time looking at these passages. I don't propose to take you through them with a fine-tooth comb in the course of my oral argument. But in my submission, on a fair reading of these passages and the judgment as a whole, and in particular the judge's exclusive reference to immigration rules in respect of whether to revoke a deportation order and the omission of any mention of rules in respect of whether to grant entry clearance, and bearing in mind paragraph 392, which makes clear the difference between those two things, what the judge is doing is looking at the Article 8 compliance, if I can put it like that, of the decision not to revoke the deportation order, and the judge is not looking at whether the appellant should be granted entry clearance.
Have a look at the last sentence of paragraph 54.
I'm very grateful. I acknowledge that.
And then there's a similar
that-
point in 55 as well.
I mean, they're being treated as two sides of the same coin. Yes, the actual question is whether it amounts to very compelling circumstances which outweigh the public interest in maintaining the deportation order, but the judge is very alive to the fact that she is also considering a decision which has the effect, the practical effect of stopping entry into the UK.
Agreed. But that is consistent with my analysis in my respectful submission. What the deportation order does is bar the appellant coming into the UK indeterminately. And the compliance with Article 8 of that state of affairs is what the learned judge is looking at. But the learned judge is not looking at whether it's appropriate to grant leave to remain for a particular duration or subject to particular conditions or on a route to settlement.
Well, she can't, of course, because that wasn't before her.
Indeed.
But
Imprisonment.
no, paragraph 55 in the middle, the absence of the appellant from the UK is disproportionately affecting Mrs. Tomlinson's mental and physical health. Very compelling circumstances, exceptional circumstances, and
His
so on.
return to us just during this challenging period is likely to be critical. I mean,
Yeah.
she's talking about now, not 10 years hence.
I mean, I acknowledge what the learned judge says, but equally, if we look at paragraph 56 and read the judgment fairly and in full, in my submission, the judge does not make any findings that entry clearance must be granted, still less that entry clearance under Appendix FM should be granted. And what my learned friends...
But you must accept that the substance of what she's deciding is that forcing them to remain apart while Mrs. Tomlinson is ill breaches Mrs. Tomlinson's human rights. That is
But-
the decision. isn't it?
Yes, an absolute bar to entry for an indeterminate period pursuant to the
It's nothing to
deportation
do with
law
an
has that-
indeterminate
has that
period.
consequence.
I'm sorry, Mr. Biggs. The focus is on now. The tribunal judge is saying keeping him out now is unduly harsh for her because she needs him here now while she's undergoing cancer treatment. I don't see how you can read the judgment any other way.
Well, I don't seek to do that. I'm simply trying to put these observations in their proper context in my respectful submission. And again, there is an important conceptual and legal difference between the relevance of these findings, which are, and I acknowledge these are significant findings when it comes to considering a later application for entry clearance. The relevance of those findings and whether the effect of the first tier tribunal's decision is to require, without more, a grant of entry clearance. That is, as I understand it, the case that is put against me in respect of ground 2.
Can I don't want you to take you out of your course, but for me that prompts what further is there? So you say, okay, I understand. Let's leave ground 1 to one side. He's got to apply for entry clearance again. In the absence of a relevant change of circumstances, what more are you saying would be needed? What more would be needed to demonstrate that Article 8 requires at least some form of entry clearance to be granted?
Well, I'm not sure.
Put it another way, what should the entry clearance officer be doing when they're grappling with it, which you accept they needed to, the FTT decision?
What the entry clearance officer should do is look at the up-to-date circumstances, apply the relevant immigration rules in Appendix FM, and I'll come to those when I deal with ground 2 in a moment, and factor in the findings made by Judge Carbani. And it may well be, because those findings should be respected, I acknowledge that in practical terms, that determines the outcome. But that is importantly distinct from a legal point of view from saying that it was binding on the entry clearance officer was bound without further ado to grant entry clearance. And you may have seen from my supplementary skeleton argument that the point of principle that we say arises under ground 2 is whether it was open to the entry clearance officer to undertake an assessment of the merits of the application for entry clearance in light of Judge Carbani's decision. Our position is firmly that that must be right. But the point that's taken against me is that that's wrong, that effectively there was only one outcome that followed as a matter of necessity from Judge Carbani's decision, and that was a grant of entry clearance. That, in my submission,
Saying
is
that the entry
importantly
clearance
wrong.
officer could turn around and say, well, I don't care what Judge Carbani says, I think it is unduly harsh on Mrs. Tomlinson.
No, my lady, and I hope I've been clear in not making that point. I've said that they're an important consideration.
I mean, I understand the point that the entry clearance officer has other things to do, which would include determining how long he should be allowed to come into the country, and matters of that nature.
To settlement as well, for example.
And the route to settlement and all of that. Now, I take that point completely, but I don't see that there is that much wriggle room with respect in the absence of fresh circumstances at the time that the entry clearance is being looked at, or departing from the fact findings that are made, or that particular value judgment made by a first tier tribunal judge.
Well, I'm not sure. I mean, I do not say that the judge's findings and the judge's sort of assessment of Article 8 was something that the entry clearance officer could go behind. I don't say that. I say that they're...
But then why are you defending the decision? Because the decision doesn't even address that.
I appreciate that.
I need to... I'd like to have a better understanding of what your position actually is.
Well, I acknowledge the force of the suggestion that in the circumstances where the entry clearance officer doesn't address at all Judge Carbani's decision, there is a Wednesbury error. But there is an important point of principle in respect of ground 2, which is the scope of the TB Jamaica principle. Because if this court concludes that Judge Carbani's reasoning and decision was binding on the entry clearance officer, then what will happen is that those in the position of my learned friend will say, well, we don't need to worry about the substance of Appendix FM or whatever, or the up-to-date circumstances, in the absence of some apparent change of circumstances. The process of considering an application for entry clearance is essentially automatic. You just follow what Judge Carbani decided. And all I am trying to do in respect of ground 2 is to prevent the court concluding that that is the right analysis.
But can I just understand that a little better? Because the case we've been taken to Al Suri and so on clearly recognise that if there is something new or a change of circumstances, then you're not, if you like, stuck
No.
with that earlier decision. That seems to me to be a critical point.
I think that's right. And when I was looking in the course of argument at paragraph 35, I did perhaps make that suggestion.
So in other words, just to pursue that, let's say you're right on ground 1, there has to be an application for entry clearance. Presumably the Secretary of State is entitled to do whatever is appropriate to ascertain whether there has been any relevant change of circumstances.
Yes.
If that is done and it is found that there is none, what is the basis for not following the FTT decision of the issue?
Well, in this case, what the entry clearance officer seems to have focused on is the fact that the suitability requirements could not be met. And they then undertook their own assessment of Article 8, bearing that in mind, that being something that the first-tier tribunal judge had not considered.
Suitability requirement is neither here nor there, because we all know that you don't have to meet the suitability requirement in order to be able to get in under Article 8.
You get back to exceptional circumstances.
And
unjustifiably harsh
that's the problem,
consequences.
isn't it? I mean, I speaking for myself, I think that the suitability requirement argument is a bit of a red herring, frankly.
Well, I would respectfully
And I'm not sure that that there was anything wrong with looking at it, because it is a different thing from whether you're subject to a deportation order. The fact is, you've had a 5-year sentence, and that
That's what it says.
Yes, but leave that to one side. Where the issue for the entry clearance officer is essentially the same when you get into Appendix FM, which is whether it's going to be unduly harsh consequences for the spouse to refuse entry, and it's identical. I can't myself see why it isn't absolutely binding on him.
Well, I think one way to look at it is to look at it in terms of the reasoning of the first-tier tribunal judge and the findings of the first-tier tribunal judge, bearing in mind the limitations,
Yes.
Point of time, for example, in respect of those matters. And I would acknowledge and accept that that reasoning and those findings were effectively binding on the entry clearance officer.
In this case.
In this particular case, right. Where I disagree with my learned friend's analysis is with the suggestion that the effect of Judge Carbani's decision was that the application for entry clearance had to be waved through without an assessment of the merits of the application for entry clearance and of Article 8. Now, when that Article 8 assessment, and that's through the prism, my lord, of Gen 3.2,
Right.
when that assessment of the merits is undertaken, one has to pay proper respect to Judge Carbani's decision. And that may well be the flaw in the decision in this case, but that is conceptually and importantly and legally distinct from the suggestion that the legal effect of Judge Carbani's decision is that there has to be a grant of entry clearance without considering the merits. That's the point between us, I think.
Well, so you use the terminology of proper respect,
Yes.
whereas against you is the argument that in the absence of a change of circumstances, it's binding on the issue in question. But I think you may also be close to accepting that on the particular facts of this case, there may not be much difference between the two.
Yeah, indeed. My learned friend could win his case on a conventional Wednesbury argument.
Yes, he could.
And the difference between my learned friend and I in respect of ground 2 is that that is the right way to look at it, bearing in mind that those findings and that reasoning are effectively to be respected. They are, in a sense, binding, but the decision of Judge Carbani because of the nature of the issue before her, revocation of deportation order, not entry clearance, was not resolved. So the issue for the entry clearance officer was whether to grant entry clearance in the light of the rules and the up-to-date circumstances. The issue for Judge Carbani was whether to revoke the deportation order should be revoked in the light of Article 8.
Well, can I put it this way, that the question for the entry clearance officer is whether to grant entry clearance.
Yes.
And in making that determination, that officer has to address the question whether under Gen 2.1 subpart para 2, whether there are exceptional circumstances which would render the refusal of entry clearance resulting in a breach of Article 8, because such refusal would result in unjustifiably harsh consequences on the partner.
Yes, my lady.
That particular issue has been determined in binding proceedings,
Yeah.
and therefore he is obliged to follow that unless there is a material change of circumstances which goes to that issue.
I think I would accept that. I hope is consistent with the way I have presented the Secretary of State's position. The Secretary of State's position is that there has to be an assessment of the merits of the application for entry clearance. In undertaking that assessment, as my lady says, in this case, that ultimately brings you to Gen 3.2.
Yeah.
And unjustifiably harsh. In undertaking that assessment, of course, Judge Carbani's reasons, because it's actually not the reason, it's the reasons and findings rather than the decision. And I think that's probably the important distinction. The reasons and
Necessary
findings.
reasons that led to the finding.
Right. Well, this is why maybe we are in Henderson and Henderson abuse.
No, we're in
No,
issue
we're in
of
issue of
stop.
stop.
Oh, sorry. Forgive me. Not Henderson. You're quite right, my lady. Forgive me. Not Henderson and Henderson, but classic issue estoppel.
Yeah,
Exactly.
And Al-Siri might suggest that that's the way to understand.
Yeah.
TB Jamaica. I'm bound to say that that's not what Lord Justice Stanley Burnton said in TB Jamaica. He said binding under the statutory scheme, and the consensus.
But Al-Siri is a more recent Court of Appeal decision.
I acknowledge that. But if one is looking at this from an issue estoppel point of view, I think you have my submission. My submission is the actual issue before the first tier tribunal was whether the decision to revoke the deportation order was compatible with Article 8.
yes.
Now, in reaching the conclusion on that issue, there was a chain of reasoning,
Yeah.
and that chain of reasoning had to be respected unless there were proper reasons for departing from it, consistently with the TB Jamaica principle. But that does not mean that the application for entry clearance did not fall to be considered on its merits, bearing in mind the requirements of the relevant category of the immigration rules and the individual decision maker's assessment, subject to what I've just said about the effect of Judge Carbani's reasoning and findings.
Yes, but you say it fall to be considered on its merits. Let's boil it down. Judge Carbani, at page 60 of the bundle, reminds herself, as well she might, that people who've had prison sentences of at least 4 years, there's strong public interest against letting them in, but the finding she makes at 54, 55, 56 is that there are very compelling circumstances, exceptional circumstances, which amount to a breach of Mrs. Tomlinson's Article 8 rights, and therefore the deportation order which prohibits Mr. Tomlinson from coming into the country should be revoked. And the case against you is that, absent change of circumstances, and there's no suggestion that there was any change of circumstances, that single issue has been decided, and that therefore the only lawful decision which could be made once the entry clearance application is made again, and assuming you're right on ground one, as I think you are, that the only lawful decision was to allow him entry clearance on some terms, probably under the rule which says for an initial period not exceeding 33 months. Mr. Balroop's conceded it doesn't necessarily have to be 33 months, but simply a flat no is contradictory to Judge Carbani's finding.
Well, what on that analysis is contradictory to Judge Carbani's finding is the failure to engage with Judge Carbani's finding and to undertake an assessment of Article 8, which then reaches a different conclusion without engaging with Judge Carbani's
Sorry,
finding.
but
You can't reach
are
a
you
different
really
conclusion.
suggesting, given what you accepted a few minutes ago,
Yes.
that the entry clearance officer could say, well, I don't think Judge Cabani did a very good job. I'm going to reach my own view and it's a different one.
No, I'm not suggesting that. The entry clearance officer would have to engage with Judge Carbani's reasons, bearing in mind the respect that's due to them in the way that I tried to explain. And in the absence of a proper reason for departing from them, they would have to be followed.
I think that the distinction between the two analyses is that you say it's Diva Sealand territory and he's bound to follow it unless there's a good reason not to. And we're saying, we're putting to you, that actually there's an issue with estoppel and he's obliged to find it unless there's a good reason not to. And it's whether you label it paying respect to or being obliged to, it comes ultimately on the facts of this case to the same thing. But what one doesn't really want to find is a situation where it said, well, you could go off on a frolic of your own and ignore what the first tier tribunal judges said if it's a necessary part of their reasoning. And I appreciate this is an unusual sort of case where it is an absolutely necessary part of their reasoning.
So I'm not sure in the end there's much between us in terms of the outcome there. And using the concept of issue estoppel, I think probably would be fairly novel. I appreciate what's said in our Siri,
Sorry, yeah.
but issue estoppel is a concept that hasn't been applied directly in this type of statutory, in respect to this type of statutory scheme.
You say we don't need to go there because you get there on conventional Wednesbury basis anyway.
I mean, there is authority as to how to approach findings of the first tier tribunal that have not been overturned on appeal, and it may be that you want to look at that. It's the Jaffa Daney case at page 273 and following. I don't propose to take the court to it now, but essentially what the court decided in that case, I think it was the Court of Appeal. Yes, it was the Court of Appeal. What the Court of Appeal decided in that case is that findings of fact that are not overturned on appeal are to be treated as binding by the Secretary of State unless they are at Wednesbury unreasonable or there's some other public law flaw. So arguably there's actually two lines of cases that are relevant here. There's the TB Jamaica line of cases which look at the effect, the binding effect of a tribunal's decision. That requires you to look at what the tribunal decided and the issues that were decided. And I think you've got my submissions on those things. And then you have the Jaffa Daney decision, which looks at reasons and findings. And in my submission, the way to analyse this case is in respect of the reasons and findings being effectively reasons and findings that had to be followed as far as they went, unless there was some proper basis for departing from them.
So you'd say follow the Jaffa.
I'm not sure Jaffa Daney is right. Is the right line, to be honest, because the decision or the reasoning, if you like, that we're concerned with here involves a value judgment and a proportionality assessment,
Indeed.
which is different from making a straight fact finding. So whereas you might be bound by a fact finding, which is Mrs. Tomlinson is seriously ill, here it's a mixed question of fact and law and actually involves a value judgment, doesn't it?
I think that's probably right. So we're probably arguably in between the two lines of cases. And that's why I've been struggling to deal with issue estoppel and whether that's significant. As I've submitted, though, the issue before Judge Carbani, well, I suppose the point against me on that, I'm sorry, I'm sort of thinking out loud now, but the point against me on that would be that the necessary building block to the decision on the issues would be...
That's what makes this case so closely aligned to an issue estoppel case, is because it was a necessary building block to the ultimate decision that it was unlawful not to revoke the deportation order.
My submission is that the court should be cautious about importing concepts of issue estoppel in the circumstances. One way or the other, we accept that Judge Carbani's reasons and findings had to be respected. the key point that the Secretary of State is concerned about in respect of ground 2 is this issue of whether the entry clearance officer had to assess the merits in the light of the relevant immigration rules. Now, I accept that when doing that, Judge Carbani's reasoning and findings had to be approached in a proper way. And so it may be in the end the way that the bench has put the point to me in terms of issue stop, and the way I put it in terms of devasealing or something like that isn't. There's not a huge amount of difference between us. But my learned friend, as I understand it, although he may say, well, I just want to win, and that's fair enough. But my learned friend, as I understand it, has argued the case hitherto on the basis that the entry clearance officer should, without further ado, have just have said, well, look, in the light of the Judge Carbani's findings and reasoning and decision, you're going to get entry clearance. That would be a serious error and would be wrong in principle. And it's
You say as a matter of principle, what the entry clearance officer should do is say, right, I'm looking at the question of whether or not you should get entry clearance under Appendix FM. I note that there is a decision of the FTT. I'm bound by the fact findings. I have to pay respect to the assessment of the Article 8. There's no other circumstances out there. I therefore apply relevant rules under the appendix, and I come up with this decision.
Yes, and importantly, when the entry clearance officer undertakes that assessment, they are required to look at the up-to-date circumstances, albeit that they may not have changed. In this case, they don't seem to have done. And the particular rule framework, which has to be given proper weight in terms of Article 8. That rule framework does include SEC 1.4. Contrary to my learned friend's position, that must be right, and I don't propose to take time on it, unless it will assist. So I think, my ladies, my lord, you have our position on grounds 1 and 2. Ground 3
I don't think any
adds nothing. That's the short.
Yeah.
I'm very grateful. That's our submission,
Yeah.
so I don't propose to say more about it. Ground 4, I think I probably do need to deal with. That's the issue of alternative remedy, and the reason I think I need to deal with it is that the correct legal analysis really matters in respect of alternative remedy. If something like my analysis in respect of ground 2 is correct, if I win on ground 1 and my analysis in respect of ground 2 is correct, then there's no reason in principle why the first tier tribunal system, a right of appeal to the first tier tribunal, would not have been an adequate alternative remedy.
Can you just help me with that? Let's say we've got this precise decision, which appears not to grapple with the earlier FTT decision.
Yes.
And the alternative, what you say is the alternative remedy is exercised. There's a further appeal to the FTT. What happens then? What happens in front of the FTT on the assumption that there's been no change of circumstances?
So the legal principles in the FTT are mercifully clear. The FTT in that appeal would apply a case called devasealing and the guidance given in that case to the findings that Judge Carbani made. And that would essentially get my learned friend home on his arguments.
Well, would they go beyond quashing the decision to refuse entry clearance?
Well, the jurisdiction of the tribunal is a full merits jurisdiction.
Yeah.
So it would decide for itself whether Article 8 was breached in the light of the correct approach to Judge Carbani's findings, applying devasealing. And this is what Upper Tribunal Judge Leslie Smith had in mind when she said, well, the first tier tribunal process is actually more favourable than the proceedings for judicial review, at least in the way that they have been pursued before her, because the appellant was making a Wensbury argument. And so you'd be looking to get a quashing order, but then there'd be a new decision. You don't know what the outcome of that would be necessarily. That decision, so essentially you just get one opportunity before an independent judge of the first tier tribunal to present your Article 8 case in the light of Judge Carbani's findings. And in my submission, being pragmatic about this case, that is what the appellant should have done.
Why isn't that all water under the bridge? Because the question of whether or not to give permission to proceed with a claim for judicial review is a matter of discretion.
It is.
That's for the judge of the upper tribunal. That discretion has been exercised, notwithstanding that there was this other potential route. Isn't that the end of it?
Well, the complication is that I persuaded Judge Leslie Smith to exercise her discretion the other way, in the light of her findings, her conclusions in respect of, if you like, the issues of principle. And so what Judge Smith said was, I'm going to revisit the question of alternative remedy in respect of
Was there jurisdiction to do that?
well, there was, and I'll take you to the authorities, my lady, since you've asked me the
You can
question.
rely on Glencore,
Quite.
Glencore and all that
I
way.
can deal with it quite quickly because there is, as
Okay.
as we pointed out in writing, there is clear
Yeah,
authority. on
there
that.
is authority. Would you mind just going back to what the FTT does? Because in this, on the facts of this case, it just seems to be honest, take a lot of unnecessary time in the FTT for it to look back to its previous decision. Here, the Home Secretary hasn't got any change of circumstances to put forward, and if I were there, in the FTT, I'd be wondering why FTT resources were being taken up to bring an appeal that really shouldn't have had to be brought.
Well, I mean, the ultimate question here is which procedure is the one that should be used? Should my learned friend, or not my learned friend, but should someone in the position of my learned friend's client have brought the appeal using the statutory mechanism conferred by Parliament to the first tier tribunal, or should judicial review, which we know is a remedy of last resort, Glencore emphasises this, should judicial review have been used? Either set of proceedings was necessary in the circumstances in this case. The question ultimately in respect of our response to ground 4 is whether it was open to Judge Leslie Smith to exercise her discretion at the substantive stage in respect of relief to say, well, you may have a point, applicant, in respect of the absence of any engagement with Judge Carbani's reasoning in the decision under judicial review, but that is something, that point, it can properly and should have been pursued before the first tier tribunal. It may be a conclusion in respect to the exercise of discretion that this court might disagree with or reach a different view. But
yes,
the question
one of the
strictly
problems
is
is-
whether
one
it was
of the
open to
problems-
Judge Leslie Smith. I'm so
Well,
sorry.
one of the problems is the upper tribunal judge deals with ground 1 in
Right.
fully, and then
But
uses
that, in
the
my
alternative remedy in relation to ground 2, which is quite hard to follow.
well, I'm sorry for jumping in, my lady. In my submission, actually, that is what vindicates the upper tribunal judge in this case, because what the judge did was to say, look, there are points of principle in this case. There's a point of abuse. There's a point of the legal effect of the first tier tribunal's decision. And if those issues, and those issues should be considered by proceedings on judicial review. That is, after all, what Judge Stephen Smith said at paragraph 5 of his reasons, and we can go to if we need to. But once the learned judge, Judge Leslie Smith, had resolved those issues in the Secretary of State's favour, she then considered what should happen in respect of the remaining issues, which with great respect are more prosaic, if you like. And the judge then formed the view in her discretion, applying Glencore and Chowdhury, that it was appropriate to lay down a marker and say, look, this sort of issue should be considered by the first tier tribunal, and on that basis I'm going to refuse to consider it in my discretion. The question for this court is whether that exercise of discretion was open to the judge. And in my respectful submission, it plainly was in the circumstances and for the reasons the judge gave.
Issue as to the effect of Judge Carbani's decision.
So upper tribunal judge Leslie Smith, the judge who considered the substantive case, looked at the issues of as to whether Judge Carbani's decision was binding and how that all worked through. She resolved those issues in the Secretary of State's favour.
Yeah.
There was then a residual question as to whether there was a Wensbury error because of the failure to engage with Judge Carbani's decision.
Yes.
The judge, looking at that, the judge then decided that in respect of that issue, if you like, the residual issue at that stage, there was an adequate alternative remedy because the first tier tribunal would not only be able to look at that, but would actually present a more favourable jurisdiction from the appellant's point of view. And the judge decided in the circumstances, having regard to the relevant authorities and principles, to exercise discretion and refuse to consider that point in the light of the availability of an alternative remedy.
It doesn't have a great deal of common sense behind it, Mr. Biggs, at all, because once you've decided that it's perfectly right to deal with points of principle by way of judicial review, you've got a binary decision. You either go to the FTT or you go to the upper tribunal for a decision on judicial review. but to say, oh, well, actually, you've got to expend the time, cost and energy of doing both, because it's perfectly okay to come to us to get the points of principle sided, but how that actually applies to your individual case, we're going to boot it off into the long grass and deal with it in the FTT, doesn't seem to me to be terribly sensible.
Well, I acknowledge that, and I acknowledge that my lady may have decided the question of discretion differently. But the question, of course, is whether Judge Leslie Smith's exercise of discretion was one that was perverse.
Yes. Well, and see which way the wind is blowing there, at least as far as I'm concerned.
Indeed, but let me just sort of grasp the nettle of my lady's observation.
Well, and also, to be fair, I mean, if the upper tribunal judge was wrong on her ground one, the decision is in any event undermined.
That then will be a flaw in respect of the exercise of discretion.
And the whole judgment is then.
Yeah, I acknowledge that, but you've got my submissions on that ground. But just my lady Justice Andrews, let me just try and grasp the nettle in respect of the gauntlet that you've thrown down. I mean, ultimately, the position of the position that Upper Tribunal Judge Leslie Smith was in was that she had formed the view that the points that the appellant was arguing, the points of law about the binding effect of the FTT's decision that were being argued, were not correct. And at that stage, she'd formed the view that actually probably what should have happened all along, in the light of her decision on the merits of those points, was that the first-tier tribunal process should have been used. That may seem impractical in a way, it may seem difficult in a way, but in my submission, that assessment was open to the learned judge. After all, looking at this case from a pragmatic point of view, and bearing in mind the exchanges between the bench and myself earlier, what the applicant could have done is put forward the substance of his ground 2 before this court, before the first-tier tribunal, and that would have been a much more efficient process. It would have resulted in an independent judicial decision one way or the other, and that would have been the end of it. And Parliament's choice as to where to allocate the burden of judicial resources, if you like, has to be respected or given some weight at least. So that's my response, my lady, to those observations. Finally, I think relief.
Yes.
If my conscious of the time, if my lord and my ladies wish to hear further from me at this
Well,
point,
we'd certainly like to hear from you on relief, and I imagine you're going to be more than a couple of minutes. So shall we break off now?
Very, very well, my lord. I mean, I think I probably won't be very long, but that's one of that's council's time estimates are notoriously unreliable, so I wouldn't want to keep my ladies and my lord from lunch.
It's not that, but I've been where you are, and trying to compress what might be a significant point into a few minutes is not always wise. Right, 2 o'clock then.
Court rise if able.